Okay, in this video I'm going to take a look at 21 tools of argument. So I'm going to look at how to argue and win. Firstly, argue for procedural advantage. What procedure is to apply? There may be more than one procedure applicable to any particular conflict or dispute. So obviously you should argue for the one that's going to give you the greatest advantage. Number two, argue that there's no jurisdiction. In other words, the decision maker or the so-called adjudicator or the so-called tribunal doesn't have jurisdiction to deal with the particular issue. Number three, argue that it is the wrong court to deal with the issue. In other words, this is slightly different from number two, but you may be in the Workplace Relations Commission or the Labour Court with somebody who's arguing, for example, that they've suffered a stress-related injury. That's an injuries board claim. It cannot be dealt with in the WRC or the Labour Court. They don't have jurisdiction to deal with it. So, you could argue that it's the wrong court to deal with the issue. Number four, something is wrong with the tribunal. Is there bias? Is there prejudice? Is there conflict of interest? I'm not suggesting for a minute that the court or the WRC or the Labour Court or anywhere else is biased or there's prejudice or conflict of interest. But it is possible, and it is an argument that perhaps you could make, and also it's one that you may make in the workplace if, for example, there was bias involved in an investigation or a disciplinary procedure. Number five, frame the issue to suit your case. There may be more than one way to frame the issue, frame the problem, and obviously the best thing to do is to frame it in the way that is most advantageous to your case. Number six, argue for an application of the rules that will result in a win. There may be a conflict of laws. In other words, does the law in Northern Ireland or the Republic of Ireland or the UK apply? Is there a situation there in the contract where the contract makes provision for the laws, for example, in Ontario, Canada to apply, and you're in Dublin? Or is there a cross-border transnational sort of element to it, again, where there may be a choice of what court ultimately would have jurisdiction to hear the case? Number seven, argue your opponent is wrong too. Okay, you might say, yes, I'm in the wrong, but he's wrong as well, and I'm going to counterclaim. Or, yes, I owe the money, but he didn't provide the service, and therefore I'm going to counterclaim for damages and loss. Number eight, argue it's not the complainant's business. In other words, he doesn't have standing, he doesn't have locus standi. Number nine, argue that the other party is tainted. They're not coming to the dispute with clean hands, or they have contributed to by their own negligence. In other words, they may have suffered an injury in your place of work or in your factory or wherever, but they may have contributed to their own injury. Number 10, argue it's too early. In other words, lesser remedies have not been exhausted. In other words, in the workplace, they may go straight to the WRC, but there may well be procedures in the workplace where the employee is obliged to canvass and raise their issues in the workplace first and exhaust them. So it could be harassment, sexual harassment, bullying, or something of that nature. Then you must use the procedures in the workplace first. If not, then you can argue that they're too early going to court or the WRC or the Labour Court. Likewise, number 11, you could argue that it's too late. In other words, the statute of limitations has run and passed and they're out of time to bring their claim. 2 years for personal injury, for example. So if it's 3 or 4 years, then you can say that they are statute barred. Number 12, the burden of proof. Is it on the other side? If it is, then you need to make that argument, and you may find that you have an easier case to defend. You may not have to prove anything, and the burden of proof may well be with the other side, and that is the case in a discrimination-based claim, for example, and in many other situations. For example, if the state is prosecuting you for a criminal act, then the burden of proof in a criminal situation resides with the prosecutor, who must prove all elements of the wrongdoing alleged. Number 13, argue that even if he wins, he deserves nothing. In other words, that the loss accruing is so trivial that the damage caused is so small and so unimportant that even if there's a technical breach of the law, you should not have to pay anything. In other words, the other party doesn't deserve anything. Number 14, argue that it has already been decided. This is the question of double jeopardy. You cannot be charged twice, or should not have to be arguing twice in your own defence in respect of the same alleged wrongdoing. So if you've already been convicted of something or found guilty, for example, in a disciplinary procedure, it shouldn't rear its head 3 months or 6 months later on. Each disciplinary should be quite separate and quite distinct, but you can't be done twice, quite frankly, for the same wrongdoing. Number 15, argue that the process was flawed. This is the old fair procedures and natural justice argument. You could make this argument if indeed the process is flawed. Number 16, you could argue about the meaning of terms and interpretation. So, in a contract, for example, or in a disciplinary proceeding, or in a staff handbook or something, what is the plain meaning, what is the dictionary meaning, what is the original intent, what's the context, what's the purpose, what's the principles. In other words, if you're looking at statute book, looking at statute law, looking at constitution, you could be looking at all of these things and arguing about interpretation. What do particular terms mean? Likewise, effet utile, this means the principle that each clause must have useful effect and have some intent. So if there's a phrase in a contract, it's assumed have some intent. There's a question then of interpretation versus construction. In other words, how many or how often or how much implied terms can you construct in a contract, for example? Because there's going to be express terms and implied terms. Next, interpretation and morality. Does the question of morality rear its head in terms of interpreting a contract or a statute? You need to avoid absurdity. You're entitled to avoid absurdity. There's the principle then of lex specialis. This means that the specific trumps the general. In other words, if two interpretations can be, or if clauses, for example, in a contract appear to be in conflict or unclear, then the specific should trump the general. Expressio unius means the express mention of one thing excludes all others. There's a rule of lenity. In a vague criminal rules should be construed in favour of the accused. In other words, he should get the benefit of the doubt. Reductio ad absurdam means if we accept your argument, it will open up a slippery slope, a can of worms, and the result would be absurd. So this is an argument you can make as well. Number 17, precedent. Precedent involves the sensible consistency in decisions. Ratio decidendi is the rule of decisions. In other words, previous judge-made law, previous decisions in the common law jurisdiction like Ireland or the UK or the United States or Canada or Australia. These decisions, precedent, do hold sway. Stare decisis then is binding precedent, and the Supreme Court will obviously hold sway and trump the High Court, and the High Court trumps the Circuit Court, and so on and so forth. Likewise with the Labour Court and the Workplace Relations Commission. But precedent, previous decisions by adjudicators, previous decisions by the Labour Court, previous decisions by courts are critical. Number 18, argue the facts. Let me control the facts, you can control the law, and I'll win every time. Because the facts are the facts, and if you can prove the facts, well then the law will kind of follow from that, and there's not a whole pile you can do about it. But if I have a difficulty proving the facts, then me being able to prove the law isn't going to be any good if I can't control or prove the facts. Then there's a number of rhetorical tricks you could use in your arguments. Non sequitur is something that doesn't necessarily follow from something else. An ad hominem argument is basically you saying that you're only attacking me, you're attacking the man, not the ball. You fail to address my argument. Then there's the question of correlation versus causation. Many people confuse this, but one thing does not necessarily lead to another. There may be a correlation there rather than causation. This again is an argument that you may be able to make. There's also the argument that the other side is drawing inappropriate reference from limited data. There's also the principle of Occam's razor. This is where there are two possible explanations for a particular event. There's a really complex one involving, for example, Martians, and then there's a simple explanation. In other words, a guy's walking down the street, slips on a banana skin. Then the simple explanation should be preferred if faced with a choice between that and a complex, convoluted explanation. Embedding assumptions in questions is another rhetorical trick. When did you stop beating your wife? Obviously implies that you have been beating your wife for some time. Number 20, argue about substantive responsibilities. Reasonable person and due diligence. Law versus equity. Form versus substance, rights versus duties, conflicting values, exceptional circumstances or force majeure. All of these impinge upon the responsibilities of the parties. In other words, take reasonable person and take due diligence. If the reasonable person acts reasonably, they will carry out their due diligence, and they should, for example, if they're buying a house, have a structural survey carried out. If they don't do that, then they can go and sue anybody they like, But there is the question that's going to be thrown back in their face. Well, why didn't you carry out your due diligence? You did not act reasonably. You simply bought this second-hand house without any due diligence, without any survey being carried out, and therefore your claim is going to fail. Likewise, form versus substance. You'll see this with tax avoidance and tax evasion. You'll see companies paying a certain amount of tax, and they may be in adherence strictly with the law. But whether it's, whether they're in compliance with the law in terms of its spirit, as well as its legality and its various terms, is answerable. There's also the question of conflicting values. There's exceptional circumstances and force majeure, in other words, acts of nature, which may compel you or force you to act outside the law, but it may be due to exceptional circumstances beyond your control. Number 21, finally, words and context. You need to beware of assumptions. Credibility is critical. If you are in a tribunal or in court, your credibility, particularly if you're a solicitor, is vital. You simply cannot buy or sell your credibility, because you cannot persuade anybody without credibility. Oral agreements then, are they worthless? Pretty much. If there's a dispute, it's going to be very, very hard to prove the terms of the oral agreements. And possession is 9/10 of the law. What I have, I hold. In other words, there is a certain element of truth in that, certain element of value in being the person in possession of, for example, a field or a property or whatever, because the other party then, if they're laying a claim to it, must disturb you and must move you, and must they bear the burden of proof, as it were. The source for these arguments is a book that I've just read, The Tools of Argument, How the Best Lawyers Think, Argue and Win, by Joel Trachtman. That's a mistake there, that should be Joel. And the link is in my description, or in the description on my YouTube channel. Hope you find this video useful. Give it a thumbs up down below. Thanks for watching, and my contact details are there. Thank you.